Hey guys, today in our mains perspective of our polity series, we'll be doing the basic structure of constitution. So Keshwananda Bharati, he recently died in 2020. So whenever we hear the term basic structure doctrine, we remember Keshwananda Bharati case, right? So he was a petitioner in Keshwananda Bharati with the state of Kerala case in the Supreme Court ruled that basic structure of the constitution is inviolable and cannot be amended by parliament. So what is the introduction? Basic and core building of our constitution. The term is not mentioned in our constitution. So basic structure is the core building and the term basic structure is not in our constitution. It is a document derived by our Supreme Court. It's a judicially innovated doctrine originated in Keshwananda Bharati case 1973. However, Supreme Court is said to clarify what basic structure constitutes because it is an evolving document. Origin of basic structure. The origins found in the German constitution, original Weimar constitution. Learning from the experience, the new German constitution introduced basic law. And then origin and evolution of basic structure in India. First, in the Shankari Prasad case 1951, it challenged the first constitutional amendment on the ground of violation of fundamental right. The Supreme Court, Parliament can abridge or take away any of the fundamental rights. Such law won't be void under Article 13. So, in Shankari Prasad case, the first constitutional amendment was challenged, and then for that, Supreme Court said Parliament can take away any fundamental right and it is not violative. Then in Golaknath case 1967, the Supreme Court said Parliament cannot abridge fundamental rights. So it said a contradictory statement to the Shankari Prasad case. A Constitutional Amendment Act is also a law within the meaning of Article 13. And then Parliament introduced this 24th Amendment Act 1971. In that it declared that Parliament has the power to abridge or take away any fundamental right. Under Article 368, such an act will not be a law under the meaning of Article 30. So, to oppose the Golaknath judgment where Supreme Court said Parliament cannot take away fundamental right, Parliament introduced an amendment and it said no, Parliament can take away fundamental right. And then only came the Keshwananda Bharati case. So in this particular case, it upheld the validity of 24th Amendment Act. It said yes, Parliament has power to take away fundamental right, but it also laid down the basic structure. Under Article 368, Parliament cannot alter the basic structure and the fundamental right is the basic structure. Then in the 42nd Amendment Act 1976, it amended Article 368 and declared that there is no limitation on the constituent power of the Parliament. So 42nd Amendment, it's called as mini constitution, right? It said Parliament can amend anything, change anything. There is no limitation on its power. Then in the Minerva Mills case 1980, the Supreme Court again it invalidated the 42nd Amendment Act and it excluded judicial review, which is a basic structure of the Constitution. Constitution had conferred a limited amending power on the Parliament. Indeed, a limited amending power is one of the basic structure also. So, Supreme Court said that judicial review is a basic structure and the limited amending power of Parliament is also a basic structure. So, both these things cannot be altered or taken away, which was told by the Supreme Court in Minerva Mills case. And then in the Vaman Rao case 1981, it adhered to the doctrine of basic structure and further clarified that it would apply to constitutional amendment enacted after April 24, 1973. So it said that whatever amendment happened after April 24, 1973, for all these things, the basic structure doctrine will apply and judicial review is mandatory. That is the date of judgment in the Keshwananda Bharati. This is the Keshwananda Bharati case judgment date. Now, what are the various cases or judgment, and how the basic feature doctrine evolved? So, first is the Central Coalfield case, 1980. It told that effective access to justice is the basic structure. And then Beam Singh Ji case, 1981, welfare state, socio-economic justice. And then SP Sampath Kumar case, 1987, rule of law and judicial review. Then in the Delhi Judicial Service Association case, 1991, power of Supreme Court under Article 32, 136, 141, 142. All these are basic structure. Then Indra Sane case, it said rule of law is a basic structure. Then Kumar Padma Prasad case, 1992, independence of judiciary. Then Kihoto Kolohan case, 1993, free and fair election and sovereign democratic republic structure. All these are basic structure. Then Raghunath Rao case, principle of equality, unity, integrity of India. Then in Chandra Kumar case, 97, powers of High Court under Article 226 and 267. Powers of Supreme Court in the Delhi Judicial Association case, powers of High Court in the Chandra Kumar case. And then Kuldeep Nair case, democracy, free and fair election. Ram Jethmalani case, 2011, power of Supreme Court under Article 32. Then Amit Sharma case, 2013, freedom and dignity of the individual. So all these were declared as a basic structure by various Supreme Court judgment. Now, what is the significance of this basic structure? It is maintaining supremacy of the Constitution. It prevented its destruction by a temporary majority in Parliament. Then it preserved the constitutional principle and basic ideals envisaged by our founding fathers. So it will preserve all the basic constitutional principle, and it will maintain the supremacy of constitution, not the parliamentary sovereignty but the constitutional sovereignty. The privileges uncertain democracy over certain tyranny. In the absence of doctrine, India would most certainly have degenerated into totalitarian state or had one party rule. So without which India would have become a totalitarian state because of Parliament's unlimited power, right? Then judiciary applied doctrine responsibly and threshold has set very high. So even judiciary uses this document judiciously. So all these are the significance. Now what is the criticism of this basic structure? The criticism is that infringement of judiciary over legislation. So every law can be considered under the judicial review. So it is a kind of infringement of the separation of power doctrine. Then there is no constitutional basis for this document. Then matter of subjectivity, it differs from judge to judge, right? Then translate judiciary into third decisive chamber of parliament. So it is kind of involving in legislation process. Then amending the constitution even to change the original intention of constitutional framers. So these are some of the criticism of the doctrine. Now conclusion. It is one of the most appreciated judicial innovation. It has been accepted by many other countries such as Bangladesh, Pakistan, etc. It is a bedrock of judicial review. It acts as safety wall against the majoritarianism and authoritarianism, thus protects the constitution and democracy in India. So it is like acting as a safety wall to preserve our democracy. Then what is the significant provision in Indian Constitution? This is the next topic. In that, India is a sovereign, social, secular, democratic republic state. The Constitution is adopted by the Constituent Assembly on 26th November 1949 and it came into force on 26th January 1950. Constitutional head is the President. Real executive power is in Prime Minister, Council of Ministers with Prime Minister as the head. So, significance of various constitutional provisions will be seen in the further days. So already we completed the preamble part, right? So that's all for today. Thank you.